Hey there, Professor Fields here. Another lesson in AJ 170 Constitutional Law for Criminal Justice. In this section, we're talking about some prerequisites for the application of the Fifth Amendment. So when we look at this, let's analyze the Fifth Amendment by its components. It prohibits compelling a person to be a witness against him or herself in a criminal case. So the requirements to invoke the protection for the Fifth Amendment are compulsion, testimony, and self-incrimination. So the Fifth Amendment only applies to testimonial evidence. In other words, somebody talking about what they did in the crime. There's a case law underneath it, each one. And testimony includes any words or actions that disclose things that a person knows. So compelling the person to speak does not necessarily invoke testimony. For example, a lineup. If you have a physical lineup, you can ask the suspect to say some words if it helps in criminal investigation. In other words, the victim heard the suspect say something but may not recognize the face but can recognize the voice. So that's an example of compelled testimony that does not involve incriminating evidence. And compulsion normally occurs when information is gained by threatening consequences. And normally what happens is they'll issue a subpoena saying you need to come to court and testify, and if you don't obey the subpoena, something's going to happen to you. Usually it's jail time or a fine or both. In California, we have a thing called POBR, which is Public Safety Officers Bill of Rights, and in that you can be compelled to testify against yourself as a police officer, but that cannot be used against you later on in a criminal case. It can be used against you in an administrative case. So say you did something wrong, maybe you misused force at work, and they're questioning you about it. You can be compelled to testify in that administrative hearing, but none of those things can be used against you later on in the court of law. Also, previous statements are not compelled statements. In other words, if you made a statement earlier to the police or even anybody else, such as incriminating records or journals or documents that you prepared on your own, that you weren't forced to prepare, the law enforcement can get that. It requires normally a search warrant to get that. And most of the time it's called a subpoena duces tecum. In other words, you have to bring all the records to the court. And the Fifth Amendment only protects against incriminations. In other words, the statements have to reveal more than criminal activity. And you have to have the disadvantage of being convicted of a crime based on what you reveal. So for example, if you get arrested, the police can ask you about your name, address, social security number, stuff like that needed for booking, because those are not incriminating statements. They're not going to be used against you to show some kind of criminal activity. And you can be compelled to testify if the statements given aren't going to expose you to a risk of conviction. One of those cases is double jeopardy. If you've already been tried for the crime and maybe you've been acquitted of the crime, you can be compelled to testify at a later time. You see this in civil suits that arise out of criminal actions. Another example is if you're granted immunity, and most of the time the government will grant you immunity if we call it catching the bigger fish. Maybe you got some information that'll help them catch somebody else they're trying to get, so they'll grant you immunity in your testimony, and you may give incriminating testimony about your criminal activity, but you're catching that bigger fish, so you get the immunity.